Hi, my name's Anthony Alder and I'm from Alder IP. And welcome to another episode in the IP series. Today we'll be talking about contract law. And contract law is not something that normal patent attorneys talk about a lot. But what I'm going to go through this episode is just the basics of what makes a contract and what makes a binding contract. The first thing that you should know about a contract is that a contract is an exchange of goods or services. You need to exchange one thing for another. In the legal interpretation of exchange, it's called consideration. And the consideration could be anything. In the legal precedents, it's talked about a peppercorn. So in one famous English case, somebody gave a peppercorn for consideration. So that sort of tells you how ridiculously low the value could be. But something has to be changed between the two parties. If you don't have the exchange between the two parties, then there is no contract and the contract's actually void. So it's important that both parties get something out of it. If you have an agreement where you don't have the two parties getting something out of it, it's commonly called a deed. And a deed is more like a promise. It's more like a legally binding promise. The problem with deeds is a lot of countries overseas don't have the concept of deeds, particularly countries that don't have common law. So they're quite difficult to enforce overseas, but in Australia, they're quite enforceable. If you're looking for overseas contracts, you're far better off to rely on just normal contract law. The question I often get asked is whether a verbal contract is binding. And yes, a verbal contract is binding. It involves all the same things that a normal written contract does. The problem, though, is reduced down to evidence. What evidence do you actually have that was what it was agreed between the parties? Particularly if you're just talking to a mate and that person agrees with you at the time, there's no recordal of what you actually agreed to except for your verbal recollection of that conversation. And quite often the two parties, when they walk away from a meeting, have completely different interpretations of what they agreed to at the meeting. And that's why there's always a preference to get your contract in writing. If it's important to you, make sure you do get your contract in writing and make sure it does cover the key points that you want in the contract, the key things that are important to you. I have a common misconception with contracts is, well, they're only binding if I sign them. Now, contracts can be, particularly in Australia, can be bound by action. And by that, if you behave in a way as if the contract was signed, then the contract's signed, regardless of whether you actually physically signed it or not. And this is called promissory estoppel. Say, for example, there's a famous legal case in Australia where one party signed the contract, forwarded it on to the other party thought they'd be clever and didn't sign the contract and just stuck it in his bottom drawer and forgot about it. And he behaved as if that contract had been signed. And then when they came asking for payment, he refused to pay it and said that he'd never signed the contract. The problem was he acted as if the contract had been signed. And so the court had found that his actions led to the contract being enacted. The last thing I'm going to talk about in contracts is called privity of contracts. And what privity of contracts is it really is this description of that there can only be two parties to a contract, or it can only be binding on the people who actually agreed to the contract. You can't bind people that have never seen the contract. And a good example of this is the relationship with confidentiality agreements. So with a confidentiality agreement, you might promise with someone to keep it secret, and they might agree in turn to keep that secret. But that promise is only binding between the two of you. If the person you disclosed it to then goes and discloses it off to another person, to your detriment, you can't sue this third party. You can only sue the party that breached it. And the party that breached it might not have the money or the resources to be able to pay for the amount of damage they've just done to you. The other problem is you might not be able to find the person who's the middleman. They might have disappeared as well, which sometimes happens with confidentiality agreements. This is something to be really important of, particularly with tech agreements and confidentiality agreements, because if you want the parties to be bound, they have to sign the contract. And that's a nice rule to end on, is that pretty much work on the basis that if you didn't write it down, it didn't happen. So if you want to have a contract with someone, make sure you write it down. Make sure you reduce it to writing. If you have any problems, talk to a lawyer. We'd always recommend that you have your contracts reviewed by a lawyer before you sign them, or before someone asks you to sign something. But if you follow these basic rules, these are the starting points for the basic contract law. I hope this was really helpful. And if you have any queries about contract law, please feel free to contact myself or the rest of the team at Alder IP, and we're more than happy to help you. And thanks for listening.